Good evening, dear students. Today I am going to give you dictation of the legal matter at the speed of 100 words per minute. Please write it. Ready? Start. Leave granted. This appeal arises from the judgment and order passed by the High Court of Chhattisgarh in Criminal Appeal number 1538 of 2021 dated 16/1/2025, by which the appeal preferred by the appellant herein against the judgment and order of conviction passed by the trial court came to be partly allowed by altering the conviction of the appellant herein from section 302 of the Indian Penal Code 1860 to section 304 part 1st of the IPC. The appellant himself lodged a first information report dated 27/9/2019 with Korba Kotwali Police Station, District Korba, which came to be registered for the offence punishable under section 302 of the IPC. Upon registration of the FIR lodged by the appellant himself at the concerned police station referred to above, the investigation commenced. It appears that the investigating officer, after arresting the appellant, took him to the house of the deceased. After breaking open the house, the dead body of the deceased was found lying in a pool of blood inside his residence. A panchnama of the scene of offence was prepared in the presence of punch witnesses. The knife allegedly used by the appellant to inflict injuries on the deceased was recovered from the place of occurrence, that is, the deceased's house. The cloths and other articles were also collected in presence of the punch witnesses by preparing a panchnama and were sent to the forensic science laboratory for chemical analysis. The clothes of the appellant were discovered at his instance from the residence of his uncle Rajnath Yadav by drawing a panchnama. Upon completion of the recording of the oral evidence, further statement of the appellant was recorded under section 313 of the Code of Criminal Procedure 1973. In his statement, the appellant claimed that he had been falsely implicated in the alleged crime and asserted his complete innocence. The trial court, upon overall appreciation of both oral as well as the documentary evidence on record, reached the conclusion that the prosecution had proved its case beyond reasonable doubt, and accordingly it held the appellant guilty of the offence of murder and sentenced him to undergo life imprisonment. The appellant, being aggrieved by the judgment and order of conviction passed by the trial court, preferred an appeal before the High Court. The High Court partly allowed the appeal and altered the conviction of the appellant from section 302 of the IPC to section 304 part 1st of the IPC, giving benefit of exception 4 to section 300 of the IPC. The only question that falls for our consideration is whether the High Court committed any error in passing the impugned judgment. the entire judgment of the High Court could be termed as erroneous on several grounds. There are errors apparent on the face of the impugned judgment. The first misstep was that the High Court examined the medical evidence on the record in detail and then proceeded to directly corroborate it with the contents of the FIR lodged by the appellant himself. Hello, was I am hello, are you hearing? The voice is audible. Hello. Next dictation at the speed of 100 words per minute. Please write down. No confession made to a police officer shall be proved as against a person accused of an offence. The terms of section 25 are imperative. A confession made to a police officer under any circumstances is not admissible in evidence against the accused. It covers a confession made when he was free and not in police custody, as also a confession made before any investigation has begun. The expression double inverted comma accused of any offence double inverted comma close covers a person accused of an offence at the trial whether or not he was accused of the offence when he made the confession. Section 26 prohibits proof against any person of a confession made by him in the custody of a police officer unless it is made in the immediate presence of a magistrate. The partial ban imposed by Section 26 relates to a confession made to a person other than a police officer. Section 26 does not qualify the absolute ban imposed by Section 25 on a confession made to a police officer. Section 27 is in the form of a proviso and partially lifts the ban imposed by Sections 24, 25 and 26. It provides that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. Section 162 of the Code of Criminal Procedure forbids the use of any statement made by any person to a police officer in the course of an investigation for any purpose at any inquiry or trial in respect of the offence under investigation, save as mentioned in the proviso and in cases falling under subsection within bracket 2, and it specifically provides that nothing in it shall be deemed to affect the provisions of Section 27 of the Evidence Act. The words of Section 162 are wide enough to include a confession made to a police officer in the course of an investigation. A statement or confession made in the course of an investigation may be recorded by a magistrate under Section 164 of the Code of Criminal Procedure, subject to the safeguards imposed by the section. Thus, except as provided by Section 27 of the Evidence Act, a confession by an accused to a police officer is absolutely protected under Section 25 of the Evidence Act, and if it is made in the course of an investigation, it is also protected by Section 162 of the Code of Criminal Procedure. And a confession to any other person made by him while in the custody of a police officer is protected by Section 26 unless it is made in the immediate presence of a magistrate. These provisions seem to proceed upon the view that confessions made by an accused to a police officer are made by him while he is in the custody of a police officer or not to be trusted and should not be used in evidence against him. Stop. You may ask the outlines of the words which you are not able to write. You may drop it in the comments. I will respond it. Next dictation. Ready? Start. Now a confession may consist of several parts and may reveal not only the actual commission of the crime but also the motive, the preparation, the opportunity, the provocation, the weapons used, the intention, the concealment of the weapon, and the subsequent conduct of the accused. If the confession is tainted, the taint attaches to each part of it. It is not permissible in law to separate one part and to admit it in evidence as a non-confessional statement. Each part discloses some incriminating fact, that is, some fact which by itself or along with other admitted or proved facts suggests the inference that the accused committed the crime, and though each part of taken singly may not amount to a confession, each of them being part of a confessional statement partakes of the character of a confession. If a statement contains an admission of an offense, not only that admission but also every other admission of an incriminating fact contained in the statement is part of the confession. If proof of the confession is excluded by any provision of law, such as sections 24, 25, and 26 of the Evidence Act, the entire confessional statement in all its parts, including the admissions of minor incriminating facts, must also be excluded unless proof of it is permitted by some other section under as section 27 of the Evidence Act. Little substance and content would be left in sections 24, 25, and 26 if proof of admission of incriminating facts in a confessional statement is permitted. If the confession is caused by an inducement, threat, or promise as contemplated by section 24 of the Evidence Act, the whole of the confession is excluded by section 24. Proof of not only the admission of the offense but also the admission of every other incriminating fact, such as the motive, the preparation, and the subsequent conduct, is excluded by section 24. To hold that the proof of the admission of other incriminating facts is not barred by section 24 is to rob the section of its practical utility and content. It may be suggested that the bar of section 24 does not apply to the other admissions, but though receivable in evidence, they are of no weight as they were caused by inducement, threat, or promise. According to this suggestion, the other admissions are relevant but are of no value. But we think that on a plain construction of section 24, proof of all the admissions of incriminating facts contained in a confessional statement is excluded by the section. Similarly, sections 25 and 26 bar not only proof of admission of an offense by an accused to a police officer are made by him while in the custody of a police officer, but also admissions contained in the confessional statement of all incriminating facts related to the offense. A little reflection will show that the expression double inverted comma confession double inverted comma close in sections 24 to 30 refers to the confessional statement as a whole, including not only the admissions of the offense but also all other admissions of incriminating facts related to the offense. Stop. This is the last dictation. It will also be at the speed of 100 words per minute. Please note down. Ready? Start. The voice of reason is heard on neither side in the heat of passion. Therefore, it is difficult to apportion between them respective degrees of blame with reference to the state of things at the commencement of the fray, but it must occur as a consequence of a sudden fight that is mutual combat and not one-side track. It matters not what the cause of the quarrel is, whether real or imaginary, or who draws or strikes first. The strike of the blow must be without any intention to kill or seriously injure the other. If two men start fighting and one of them is unarmed while the other uses a deadly weapon, the one who uses such weapon must be held to have taken an undue advantage, denying him the entitlement to exception 4. True, the number of wounds is not the criterion, but the position of the accused and the deceased with regard to their arms used. The manner of combat must be kept in mind when applying exception 4. When the deceased was not armed, but the accused was and caused injuries to the deceased with fatal results, the exception 4 engrafted to section 300 is accepted and the offences committed would be one of murder. The occasion for sudden quarrel must not only be sudden, but the party assaulted must be on an equal footing in point of defense. At least at the onset, this is especially so where the attack is made with dangerous weapons. Where the deceased was unarmed and did not cause any injury to the accused, even following a sudden quarrel, if the accused has inflicted fatal blows on the deceased, exception 4 is not attracted and commission must be one of murder punishable under section 302. Equally, for attracting exception 4, it is necessary that blows should be exchanged even if they do not all find their target. Even if the fight is unpremeditated and sudden, Yet, if the instrument or manner of retaliation be greatly disproportionate to the offense given and cruel and dangerous in its nature, the accused cannot be protected under exception 4. It is not possible to enunciate any general rule as to what shall be deemed to be a sudden quarrel. It is a question of fact, and whether a quarrel is sudden or not must necessarily depend upon the proved facts of each case. For the application of exception 4, it is not sufficient to show that there was a sudden quarrel and there was no premeditation. It must further be shown that the offender has not taken undue advantage or acted in a cruel or unusual manner. The expression undue advantage close as used in the provision means unfair advantage close. Section 304 of the IPC prescribes the punishment for culpable homicide not amounting to murder. Part 1st of this section provides that if the act by which death is caused is done with the intention of causing death or causing such bodily injury as is likely to cause death, then the punishment may extend up to imprisonment for life. This was the last dictation. Hope you might have written well. We will meet again tomorrow at the same time. Good night.